I'm former prosecutor Neil Schaus, and I'm here with former police officer Michael Scafidi. We're now both criminal defense lawyers. And Mike, today I want to talk about possession of a controlled substance. So, Health and Safety Code Section 11350. And really, let's start by talking about possession and then controlled substance.
Okay.
But first of all, possession. And here in California law, possession is defined more broadly than simply having something in your pocket or on your person, right?
That's correct. When people think of possession, they think, well, I didn't have it on me. Mm-hmm. Well, California has an expansive definition of possession. For example, if it's in your immediate control, if you're in a car, and let's say you're driving, but the substance, whether it's heroin or cocaine or speed, is underneath a seat or something, or in a glove box. You own the vehicle. It's in the trunk. Something where you have dominion and control actually is going to equal possession under California law.
Even if it's not physically in my possession.
Even if it's not physically in your possession, correct.
Now, let's say I have it at home. Let's say I'm in Los Angeles and my home is in San Bernardino, and the police raid my house and I have cocaine in my bedroom, but I'm nowhere near where the cocaine is found. I mean, is that still in my possession?
It can still be in your possession. For example, what the police are going to do is they're going to try to establish that you have dominion and control of that residence. And typically how they're going to do that to see if the utility bills are in your name, if the deed is in your name, if people see you living there, things of that nature. So just because it's not physically on you, and a lot of our clients get confused by that. They're saying, Mike, I got arrested for possession of heroin, but it was at a cabin that I go to once a year, and now the cops are saying it's mine. I had friends use the cabin, and they're saying that even if it's not on me, that I possess it.
Sometimes that can really go to an issue of proof, whether the prosecutor can prove that it belonged to you or somebody else maybe who lives at the residence or other people who had access to it at the location.
That's correct. In that case, and actually that was a filed case in San Bernardino County, here in San Bernardino County, and we were able to get that case dismissed. We were able to prove that even though it was our client's cabin, he didn't really have dominion control of it, that there were other people in and out of it. And ultimately, we were able to convince the DA here in San Bernardino to dismiss that case.
So ultimately, though, I mean, the bottom line is that it's in your possession if it belongs to you, even if it's somewhere else, and not physically in your possession at the time.
Oh, I think that's a true statement under California law.
Now, so that's possession. Now, what about controlled substance? I think we all, know the sort of obvious examples of heroin, cocaine, methamphetamine. But what about prescription drugs?
Oh, that can be a controlled substance. And actually, the definition in California of a controlled substance is any chemical component drug that is covered under the Controlled Substance Act of the United States. So it doesn't have to just be what we typically think of illegal drugs. Things like heroin, speed, cocaine. It can actually be medications.
If I don't have a lawful prescription.
If you don't have a lawful prescription. If you have a prescription, of course, then you're going to be exempt from being in possession illegally.
So if the police find me with codeine, Xanax, hydrocodone, and I don't have a prescription for it, I can't prove that it was lawfully prescribed, then I can be charged for possession of a controlled substance.
They're going to charge you with an 11-350 possession of a controlled substance. Cops are trained to always look for the higher charge. So they're not going to say, oh, I'm just going to book you for the littlest thing I can, simple possession. They're going to look to get you. They're going to look for transportation. They're going to look for possession for sales. And these are the things that we'll typically see throughout our state.
So, Mike, if somebody does get convicted of Health and Safety Code 11350, possession of a controlled substance, what penalties are they looking at?
Well, let's talk about the worst case scenario and the best case scenario.
And by the way, it's a felony, right? It's always a felony.
11350 of the Health and Safety Code is always a felony. It does not what we call wobble down to a misdemeanor.
So if you get convicted, what's the story?
Well, worst case scenario, you can go to state prison up to 3 years. Typically, if you get a state prison commitment, it's 16 months, 2 or 3 years in prison.
But that said, a lot of times there's diversionary programs available.
That's correct. In California, we have through Penal Code Section 1210, also known as Prop 36, drug diversion. Typically here, you'll see the program being about 18 months long. And you'll have to report to court often, and they'll give you some counseling, and there'll be an actual formalized drug class.
And very similar with PC 1000, right?
Yes, PC 1000.
These are both, very similar concepts. The idea is that you're on probation for a while, you do a drug treatment program. If you don't violate your probation, you don't test dirty, and you complete the program, then ultimately you get the case dismissed.
Correct, you do. And PC 1000 is also, like you said, a diversion program. So if you're thinking in terms of diversion here in California, you're thinking of PC 1000 and Prop 36.
So, that's great news for somebody who is convicted, because there's alternatives to going to prison or jail and the chance to get the case dismissed ultimately. So, Mike, we've had a lot of success in defending clients who are charged, with drug possession. Tell us about some of the strategy that you employ in those cases.
Typically, in defending cases like this, there's a three-prong attack. First, legal issues. Second, factual issues. And third, mitigation issues. For example, legal issues. We have found that oftentimes police make warrantless arrests without probable cause, and searches without probable cause.
Illegal search and seizures.
Illegal search and seizures.
Violating people's rights.
They violate people's rights, and we bring a motion to suppress, and we get that case thrown out of court. Second, there's factual issues. For example, someone's riding in a car, one of our clients are riding in a car, they get pulled over by the police. There's 4 people in that car. There's a balloon of heroin in the center console. The police have a very difficult time, and they're going to have a difficult time proving whose drugs that was.
And that's such an important point, because ultimately, at the end of the day, before someone can be convicted, the prosecutor has to prove beyond a reasonable doubt that it belonged to our client versus one of those 3 other guys, right?
That's correct. And the standard for reasonable doubt is very hard. It's a very big standard for the DA. And when you have other people that have access to that center console, first of all, the cops do a lousy job collecting evidence. That's another factual issue we explore. They're not fingerprinting the balloon of heroin. They're not doing that. It's not CSI. You're not going to see that in a simple possession case. So oftentimes we can prove reasonable doubt in a jury's mind, and our clients will not be convicted. And finally, the third factor, and this is an important factor, because there are occasions when the police can prove their case. They have not violated the client's rights. They've done their job lawfully.
Our client confesses.
Our client confesses. We have that all the time. And now we look for the third factor. It's called mitigation. What about our client can get him diversion or her diversion, which, if successful on diversion, they're eligible for a dismissal of all those charges after completing either the PC 1000 program or the Prop 36 program.
So the best case scenario is really sort of winning the case on a legal or factual issue, because in that case we can get get it thrown out of court or completely dismissed, and our client never even has to be on probation. But failing that, even with a conviction, most of the time we're able to get our client into a diversion where they don't go to jail, they get some treatment instead, and ultimately can get the case dismissed.
That's correct. 100% correct, Neil. I always hope to get it resolved to a legal issue, issue number 1. This way I don't have to expose my client to a prolonged, protracted litigation. Next thing we look for is number 2, the factual issues, and finally, number 3, the mitigation issues for diversion.
So, and if somebody does have, if one of our viewers does have a drug charge, certainly before going in and pleading guilty, it would behoove them to come in and sit down with us, let us explore the whole story, because there may be legal issues, there may be factual issues that can win their case that they're not even aware of. And there may be a better route than simply going in and, pleading guilty for PC 1000. So we're certainly willing for free to sit down at the front end and talk to the potential client, go over their case, see what can be done, and really lay out the best strategy.
I would agree 100% with that. In fact, it is a rare occasion when someone comes in for a free consultation where they do not leave that consultation with a greater knowledge and understanding of, number one, the law, number two, the factual issues that can be explored in their case, and number three, the potential mitigation issues and the diversion issues.